So good morning. My name is Brendan Manning. I'm the Vice President of Education and Environment with the AGC of New York State. I just want to give it 1 minute. We've got several people. We have 169 people registered for the webinar today. So just want to give it a minute for people to filter in here. I see them slowly starting to come in. I want to introduce our speaker for today. Mary Parrish is with it's a workers' compensation board, and they're part of the Advocate for Business. So Mary's going to be covering the presentation today. Any questions that you may have throughout the presentation, what we'll do is we'll save them till the end. You should have a Q&A box. If you could type in your questions in the box, that would be appreciated. We will then follow up at the very end of the presentation and go through the Q&A. And what we'll do is we'll obviously, as part of doing that, we are also recording this presentation, so we'll have this for future use. This presentation is a joint presentation with the AGC, NESCA, and Eastern Contractors Association. So I want to welcome all of our members from all of our associations. And with that, I'll turn it over to Mary.
Well, thank you, Brendan. Good morning, everyone. I'm Mary Parrish with the Workers' Compensation Board Advocate for Business Office. Anthony apologizes that he was not able to be here today. That's Anthony Tomaselli, who is the Advocate for Business. So today we're going to introduce ourselves, what our office does, go over the coverage basics, who needs to have coverage, how to control premiums and penalties and loss prevention, and what happens if there's an injury, and then conclusion and resources, of course. Okay, introduction. What is the Workers' Compensation Board? The board was created in 1914 after the Triangle Shirtwaist Factory of 1911, where 146 workers lost their lives, mostly women and children. It brought to light the sweatshop industry in the United States, and it caused a lot of laws to be written to protect injured workers. The board oversees workers' compensation, disability benefits, and the New York State Paid Family Leave Program. We receive reports of injuries and payments and authorize medical providers when there is an injury. We handle those. We have approximately 1,000 plus employees with offices in about, I think there's 26 hearing points statewide, which are now back open for. New York City was the most recent one that just opened, Manhattan office. We hold hearings to adjudicate any disputes that are happening in the injured worker cases. The Advocate for Business, the office that I'm representing, we assist businesses with coverage and compliance issues. We do presentations like this to help educate business owners, government personnel, business associations, and employer groups. And we report directly to the chair. Right now, that is Clarissa Rodriguez is the chair of the Workers' Comp Board. There's nobody in between her and us. So you're going straight to the top when you contact our office. Oops, sorry. Oh, coverage basics. Okay. Workers' compensation insurance covers on-the-job accidents, illnesses, and injuries. It provides medical care coverage and wage replacements if the employee is pulled out of work. It protects not only the employees, but it also protects the employer, because then it's a no-fault system, just like having car insurance. If you get into an accident, your car insurance pays. So if an employee is hurt on the job, the insurance pays. Disability insurance covers off-the-job accidents and illnesses and injuries. You must be under the care of a medical professional. It only provides limited wage replacement. There are no medical benefits. The employee would have to use their regular private insurance that they get through their employer or that they purchase their own. Claims are to be filed with the employer within 30 days of becoming disabled. Right now, the minimum requirement is that employees can receive a wage replacement of up to $170 a week for up to 26 weeks. There are programs to actually enhance that. If an employer wants to do nice things for their employees, there are ways to get that improved up to 100%. And we do have some employers that do that, but the minimum is $170 a week. Paid family leave, this is the most intense in the entire country. It protects the employee when they need time to bond with a new family member, a child, through birth, adoption, or foster care, or if they have a family member that has a serious health condition that needs care from a family member. And it also assists when a family member is deployed overseas in active duty. Who needs coverage? Any business with an employee, number one. Workers' compensation insurance must be in effect day one of that employment. When it comes to the disability and paid family leave, after 30 days of employment, the employer has 4 weeks to get the coverage in place. And the 30 days do not have to be consecutive. Employee definition, anyone who provides services of any kind to a for-profit business can be determined to be an employee of the business. When it comes to nonprofits, 501c3s, it's compensated individuals with the limited exceptions of clergy and teachers. So if, I don't think anybody here is going to be a nonprofit, but the rules are slightly different. So basically, anybody who provides services for a business, and that person can actually be a family member, could be a spouse, it could be a child, a niece, nephew, somebody helping you, whether they're paid or not. If it's a for-profit business, they could be considered an employee. Who's not required? Sole proprietors, people with no employees, a sole proprietor, partnership, 1 or 2 person owned corporation that has no employees. Once you have a third person in the corporation, a third owner, then you have to get coverage. LLCs, limited liability corporations, if all the people that are being compensated are members of the LLC, then they have to be legal members. You don't have to have a workers' comp policy. But if you have anybody else that is not one of those, then you would have to have coverage. Who can waive paid family leave? Basically, they can't. There's only some certain circumstances where part-time or seasonal employees might qualify for a waiver. Employees who work limited hours may qualify for the waiver, but mostly it's not negotiable. Disability insurance, paid family leave for the sole proprietors or self-employed individuals. The employer, when he or she are setting up their business, they may opt in for coverage. If they do within the first 26 weeks of starting their business, the first 6 months, then they would be covered immediately. There is no waiting period. So if they're starting a business and they know that they have an aunt or an uncle or their parent is going to need help, and they're going to need to be able to use that benefit, then they would, if they do it within the first 6 months, then they're immediately covered. If they wait until after 6 months of opening their business, then there's a 2-year waiting period. All right, independent contractors. This is a very intense list of factors to determine if someone is truly an independent contractor. And if it goes to a hearing, the judge is going to ask several questions. These are the top 3. Does the hiring business have control over which the work is to be done? Does the individual that you're hiring have their own federal tax ID number and file their own taxes? Do they maintain a separate business establishment from who's hiring them? Also, does this individual also work for other businesses? Are they of the same type of business? Like a carpenter can't hire a carpenter as an independent contractor because it's the same business. But if hire an attorney, let's say, to do a land deal, purchasing a piece of property or selling a home or whatever, that attorney is generally working for someone else as well. You're not their only client. So generally, in that situation, they would be independent of your business. You can always go to the board's website and type in the employer section, type in independent contractors, and there's a whole laundry list that will come up. There's the construction industry, the trucking industry, and all other industries. There's several listings there. And the Construction Industry Fair Play Act, which is actually designed by the Department of Labor. They will say that they presume that all workers are an employee unless the worker can provide proof that they own their own business. Such a general contractor will hire other people, and generally those other businesses have their own business. They're not all general contractors. General contractors under the law are liable for any workers' compensation claim for uninsured subcontractors. We have two recommendations. Number one, general contractors, when you're hiring a subcontractor, ask to be listed as a certificate holder of their insurance policy and get a copy of that certificate of insurance. The other one is you can also get a policy of your own. And just as a fail-safe, in case a subcontractor, they don't get the coverage or their coverage lapses, then your policy would then cover any injuries that may happen. But as long as you get to be an insurance certificate holder on the policy, you should be fine. You do also have the right as a general contractor to require any subcontractors have insurance, whether they're in an independent contractor's sole proprietor with no employees or not. I did run into that in Rochester a couple weeks ago. A gentleman said, well, I'm a sole proprietor. I have no employees. Why did I have to have insurance? I said, what was the situation? He said it was construction. And there it is. The general contractor required that he get a policy because they did not want to be considered the employer of that independent contractor if there's an injury. So you do have that right as a general contractor. Premiums and penalties. Premiums are determined by class code. How hazardous is the business? The rates are based on $100 worth of payroll, the size of the payroll, how safely the business is operated. The annual audit by the insurance company will go through and they will check and see about who has insurance, and they will carve those people out, those businesses out of your audit. But they will look and see if there's exposure that they didn't know about. They will adjust your rates up or down depending on the audit. And there's also administrative expenses that the insurance companies will charge for. Class codes are actually written by the NYSERB, the New York State Compensation Insurance Rating Board. That's not us. That is a completely separate state agency. The assessment rate, this is what the Workers' Compensation Board, takes from your premiums. You pay, say, $500 in a premium. We take 7.1% of your standard premium as our operating expenses. This is a decrease from last year of 9.2%. So we're looking at saving New York businesses about $191 million. That's our goal. So if your insurance premiums go up, it's not because we raised our rates. We didn't. We actually decreased them by 2.1%. So talk to the insurance company and find out why your premiums went up. Disability and paid family leave, again, rated on $100 worth of payroll. The employer in this situation can deduct some of the wages from the employees to pay for the policy. They can, and it depends on the policy you do. If you do the statutory minimum for a disability, then you can only charge up to 0.5%, but no more than 60 cents a week to pay for, pay the cost of that policy. The employer pays the rest. So if the employer does do an enhanced disability policy, then the employer can only charge up to 60 cents a week if that's 0.5% of the wages, and the employer would pay the remainder. Paid family leave. This is, again, a full payroll deduction up to 0.388%, which is a maximum annual from the employee of $354.53. If the paid family leave policy is more than that, the employer would pay the remainder. The penalties. Penalties are very stiff. Initially, the penalties are set at $2,000 for every 10 full days the business is out of compliance, up to $72,000 a year. This is across the board. Doesn't matter if you're IBM or if you're Joe's Plumbing that has no employees. If there's a penalty assessed, this is how the penalties are initially assessed. If you have up to 5 employees, it could be considered a misdemeanor with an additional $5,000 penalty. More than 5 employees could be considered a Class E felony, excuse me, with an additional $50,000 penalty and up to 4 years in prison. We don't know if anybody's ever been sent to prison, but we don't want that to happen either. Misclassification, again, the class code of your employees, the class code of your business. Don't mess with that, because if you misclassify and you say your roofers are actually secretaries in the office, that's the penalty is going to be the same as if you did not have insurance. Disability and paid family leave. This is actually $500 plus half of 1% is the initial penalty. And again, there's a misdemeanor subject to another $100 to $500 penalty, and imprisonment and additional violations up to $2,500. Again, I don't know of anybody that's gone to prison. We haven't heard of anybody yet. We've been asking, but we just don't want the business to be without the coverage that is required by law. If you do find yourself without coverage, you will wind up on the debarment list. The debarment list is for 1 year, and in the construction industry, this can be catastrophic to running a business, because then you would be barred from bidding on or being awarded any public works contract or subcontract with the state or any municipal office, local counties and villages. And you would be on the debarment list for an entire year. And if you have the 5 or more employees and it's a felony conviction, then you're barred for 5 years from bidding on contracts. If you get a penalty, please give us a call. What you first get from the board is an inquiry letter. Don't ignore it. I know a lot of people, they get this letter in the mail, workers' comp. I don't have any employees. I don't need workers' comp, and then toss it in the file or in circular file. Then the next thing they get is a penalty letter. $5,000, $7,000, whatever the penalty is, because it's $2,000 for every 10 days. They ignore that because I don't owe the state any money. I don't have any employees. The next letter, you're looking at like maybe 20,000, and it can go to up to a judgment if it goes for over a year that you do not respond to us. And then that's much more difficult to resolve and get yourselves cleaned up and off of the debarment list. So give us a call, contact the board, email us. I'll give you the information later, and we will negotiate the penalty down if there is a reason to still have a penalty. If for some reason, let's say the business shut down for a short period of time, that happened a lot with COVID, businesses shut down, then after COVID lifted, then they started ramping up again. During that time period, you might not be required to have workers' comp, or if you no longer had employees for a period of time. So there's a lot of pieces to this that we can certainly explore and see if we can make part of that non-compliance period not required to have coverage, or maybe you had insurance and the board just never got the notification from the insurance company. So there's a lot of pieces here. Controlling costs and your safety prevention. Premium costs, be sure you have, again, the right classification. Don't list your roofers as secretaries. It's a big no-no. That's going to cause serious issues. If there is a claim, keep in touch with the employee and your insurance company. Your insurance company is actually your legal representative in any workers' compensation injury case. They will protect your rights, your benefits, and your premium, your policy. So keep in touch with them. And the last thing is operate safely. The best accident is the one that never happens. If you can, Depending on the size of your business, you might be able to institute a labor management safety committee. This is an awesome idea to have management and laborers getting together on a regular basis and review the different areas in your workplace. Look at the different equipment. Make sure that there's no broken belts or broken chains or anything that could cause a health or safety injury. Establish procedures and train people for safety. Make sure they're using their PPE. Make sure if they're on a high elevation that they are latching themselves in with proper safety equipment. If you can't, if it's a small business, then maybe the owner and one of the employees get together and go through and look at the different areas and see what you can find as maybe something that can be improved on so that somebody doesn't get hurt or injured or ill. Department of Labor has a free program and it's confidential. They will come out to your workplace and they will assess any injuries or potential hazards that they can find. They have OSHA trained staff and they will do this free of charge, as I said, and they do not go out there looking to find things to penalize you for. That is not their purpose. Their purpose is solely to help you have the safest work site that you can. Code Rule 60, if you are not already part of a safety prevention program, a business can opt in to this voluntary system. And what it does is a three-part system. You set up a safety program, a return to work program, drug and alcohol program. You don't have to do them all at once. You can do them one at a time. But for the first year, let's say you did all three of them at once, the first year, you would get a 10% discount on your insurance premiums. Then every year after that, it would be 6, two, and 2. If you, after the 3 years, you want to renew it, it is renewable. Just like taking a defensive driving course for your car insurance. When it's over after the 3 years, you renew it. You do the program again. Once you're in this program, it's so much easier to just keep it going and keep getting that 6% reduction in your premiums. And here we go, the Code Rule 60, drug and safety alcohol programs. It should be evaluated by a certified specialist. Some insurance companies actually have people that do this. I know the State Insurance Fund actually has a department of their own. If you need more information, certainly go to Workplace Safety Loss Prevention on the DOL's website, and they'll give you a list of certified specialists and model programs and help you through the process. The return to work, again, if you've got a valued person and they just got hurt and they're out of work for a couple of weeks, you want them back because they're a good worker. So this is the return to work program that you want to get them back. Find a way to get them back into the office or get them back onto the job site. Maybe they would have to do light duty work for a while. The insurance will pay the difference. I think that might even be on the next slide. Reduced earnings. So again, your insurance is going to pay all of this. The employer doesn't pay any of it, but you want that employee back as soon as you can so you can keep going on your project and get the work done. Return to work programs, initiatives, and here's the reduced earnings benefits. They're provided if they return to work at a lower rate of pay because of their disability. Maybe they're answering phones because they can't be on the roof, but they're at least back to work and they're working full time. They're just getting paid less money. So then, like I said, the insurance company will pay the difference on the reduced earnings. And they still get medical care and for any illness or injury. It's a lifetime benefit unless they sign off with a settlement. But basically, workers' compensation, they are covered indefinitely for a workplace injury or illness. And if there's an injury, what do you do? First of all, make sure the employee gets the medical care and treatment that they need right away. If you need to, call an ambulance, get them to urgent care. patch them up with Band-Aids, whatever they need, get that care. Then make sure as an employer that you also record, do an injury report that you keep in your files. What happened? Where did it happen? Who was involved? Were there any witnesses? Then you contact your insurance company. This is basically just like if you have a car accident, what do? Is somebody hurt? Get the medical care. Get a police report if you need to have a police report because there's major damage. And then you notify your insurance agent or insurance carrier that you had an accident with your car and you're going to put in a claim. So it's basically the same idea. If the employee files a C3, they have 30 days to notify the employer in writing, not a text, that they're going to file a workers' compensation claim. They file the C3. If the employer does not believe, and they hear within 30 days, they do not believe that this actually happened, the employer can challenge the claim. It's called controverting. The insurance company, again, notify your insurance company. Employee A decided that they had a workplace injury 2 weeks ago. We have no record of it. We don't believe this happened. Let the insurance company know. They will file the proper forms. And then it will go to a hearing in front of the workers' comp law judge. If you believe that the claim is truly fraudulent, definitely controvert that claim. Employers decide that they're going to let the employee use their paid time off. They've accrued vacation time, sick time, whatever is in the contract that you have with the employee. The employer is more than welcome to use that time, especially if the employee says, I can't be without a paycheck. Okay, use my sick time, use my sick bank, my vacation bank. If you do that and you pay their wages, wonderful. But make sure you tell the insurance company that you are paying wages, because once the employer stops paying wages, the insurance company has to immediately kick in. And this way also, if you want that money back from the insurance company, then the insurance company has to give you the proper form to file for the reimbursement of the awards of out of any further awards of compensation. So they would have to provide you with the form that you would file requesting a reimbursement. When the injured worker returns to work, you know when the injured worker got back to work because they're working for you. Don't trust that they're going to tell the insurance company, because a lot of times they go back to work, they forget that they have a workers' comp injury case. Then they're going to be getting additional checks for the insurance company that then they're going to have to return, or if they cash them, they're going to be in serious trouble and have to pay the money back. So make sure the insurance company knows that the person has returned to work. If they're coming back for limited or light duty and they have reduced earnings, the insurance company again needs to know how much they're getting paid, and then they will make up the difference. If they're returning to their old job at a previous wage, then they don't have to have any wage replacements. Then they're done, they're back to work, basically case closed. They still get the medical care, however. If they return to work without disclosing it, the employee can face fraud charges because that's double dipping. Medical care and treatment, again, for work-related injury or illness, is a lifetime benefit unless they sign off on a settlement. The employer's responsibilities. Number one, employers should make sure they get the proper insurance that is required by New York State law. Number two, don't let the premiums lapse. Make sure they get paid on time. Even if you're in a dispute with the insurance company about a previous audit, pay those monthly bills or however you've got it scheduled. Do not let them cancel you for non-payment, because that's a disaster waiting to happen. When you get an insurance policy, you're going to, just like your car insurance, you're going to get an insurance card, an insurance poster for workers' comp and disability. That has to be displayed in Areas that are accessible by all employees, such as a break room, a hallway, if there's a time clock, over by the time clock. Display it where the employees can find it. If they have an injury, then you can tell them in the break room on the bulletin board, there's a poster. It's going to tell you the workers' comp insurance. Contact them at that phone number there. And then they have access. Report the claims timely to the insurance company. Again, communicate with your insurance company. And employees cannot be discriminated against if they file a workers' comp claim. You cannot terminate them because they filed a workers' comp claim. Insurance has got them covered. But you can terminate them for valid business reasons, such as misconduct, insubordination, lack of work. You need to lay them off. You don't have enough work for them. A lengthy absence from work that is not workers' comp related. They're not able to do the job, or they do a really lousy job. You can terminate them for cause, just not because they filed a workers' compensation claim. And all employees that work for you are covered by the insurance, regardless of citizenship or immigration status. Anybody who works for you is covered by that insurance policy. If anybody is still around that was a responder or worker or lived, or a student that was in the areas that were hit in the 9/11 attacks, we still have that program going on, and it will probably continue to go for quite some time. So just go to the ny.gov/September 11. If you know of somebody who is having medical issues, that might be a good place to suggest that they turn to. The board is upgrading its system. It's called Onboard. It's actually taking all of the multiple systems that we have, and they're combining them into one so that they interface better. It's a long process, so it's I don't know when it's going to be completed, but it's going to be quite a while. But you're more than welcome to sign up to get information about the Onboard and walk through a registration process and view videos and recorded presentations. But this is what the Onboard is. If you hear about it, it's just us streamlining and getting all of our systems talking to each other at the same time. The board can be followed on all of the social media platforms: X, Facebook, Instagram, YouTube, LinkedIn, and most of our presentations are up on the board's website. If you go to the board's website, and down at the very bottom, there's a Get WCB Notifications. Click on that link, and every time, or every one of the ones that interests you, you want to know about. Every time the Advocate for Business is having a presentation, you would check that box. There's a bunch of boxes. You check the ones that you are interested in. You can update it at any time. Just go back in and change your notifications. And this way, every time we have a WebEx, or we have a lunch and learn every month, and you'll be notified every time the board's having another lunch and learn, which you'll get basically the same presentation that you're getting now. If you need to contact our office, please, our phone number here is direct to our office. It does not go through the call center. There's no menu or options that you have to press. As when we're in the office, if there's one person on the phones, it will be answered. If the person is on the phones and they're busy, it will go to voicemail. We get that voicemail immediately, and we will respond to you, generally within the same day. Same with our email, advocatebusiness, one word, at wcb.ny.gov. Send us an email if you have any questions. If you get a letter from us and you don't know what it is, send us a copy of it. Take a scan of it and send it as a PDF attachment, and then we can, on your behalf, contact the compliance department and see what we can do to help resolve your issue. We also have our own little separate website, which is wcb.ny.gov/AFB for Advocate for Business. And you'll see on there a picture of Anthony when you go on that screen. Okay, that is what I have to present to you. What questions do you have for me, please?
Thank you, Mary. There are four questions that have come up in the Q&A column.
Okay.
I'll read these out. The first three in general seem to be Just some concerns more than anything, and some questions that maybe obviously can't be answered here today, but the first one was basically just says it's a major issue when an employee with no injury history puts in an OD claim. Workers' comp board in this case no longer goes the employee through the employer work history to assign percentages to past employers. Now the workers' comp board puts the burden on the last employer. I know this because we paid a 2-month employee with no injuries $472,000. How can we get this change back to the way it was?
Um, we have no control over how the judges decide when it is an occupational disease, such as a hearing loss claim. And the person worked in multiple factories. And some of these factories are no longer in business. It's very difficult for the board to, they call it apportioning, that maybe a portion of this hearing loss was created by, was received, the employee received this injury from this business that's no longer in business, and maybe their insurance is no longer in business. Unfortunately, if there's nobody left to pay, then it might go back to the most recent employer. If all the other employers are gone, all the other insurance companies are gone, then there would only be one insurance company in business to actually carry the burden. And unfortunately, with an OD claim, it's very difficult to determine that. So without knowing the case, and I am not a judge, I would not be able to make a determination on that.
Okay. Next one is this, I've participated in situations where employees were given workers' comp benefits, even though video showed the employee fraud. Workers' comp judge are not taking the testimony as truth from employee supervisors. Would it be possible to have an impartial third party be the deciding factor?
As the employer, your insurance company should be fighting that. If you did not notify the insurance company, then I know I'm just using State Insurance Fund because they're the largest, but they actually have fraud investigators that go out and they take videos and they interview people to make sure that the employee that said that they hurt their back on your job isn't out there shoveling their yard. So you need to communicate that with your insurance company, because the insurance company, as I said, they are your representative. They actually will generally send an attorney to any workers' comp hearings. I hope that answered that question.
Sure. Next one is just say the fact that there's a large majority of individuals that put in OD claims upon retiring from a union some years later when reaching retirement age for Social Security benefits. That's the question. How does one go for many years without treatment and then out of the blue reopen a claim? Many quickly ask for an SLU and get a nice chunk of money while the employer winds up with the higher insurance rates. Again, there's a need to be qualifying factors and conditions for reopening the claim years old. What can we do?
Oh, I feel your pain. Unfortunately, the New York State legislature is who created or wrote all these laws that we have to adhere to. You can contact your local legislator and let them know the problems you're having and keep in touch with your insurance company. Yeah, I know people retire and then they find out, oh, you have hearing loss. And then years later, they went to Miracle Ear, they went to their hearing audiologist and they said, oh, you have hearing loss, you need hearing aids, and they're this expensive and they don't have the insurance for. Well, what did you do for a living? Oh, I worked in a factory. Oh, well, maybe it was OD. So unfortunately, this is going to happen, especially with OD claims, and that's why they're so sticky as to who is totally responsible or who is partially responsible, and then portioning out who else is responsible for the claims. ODs are some of the hardest ones for us to determine, to be perfectly honest.
Okay. One last question we have here. It just says, any tips to properly terminate someone due to lack of work?
Yes, you can just say that if you can prove that your workload has reduced and you don't need these additional employees, you would terminate them for that reason. You just cannot tell them it's because they're on a workers' comp injury timeout. If it's the same person, just make sure that in your termination that you say it's for lack of work. Then they would, once their workers' comp is once they're medically cleared to return to work, then they would apply for unemployment.
One last question just came in. It just says, if an employee is laid off for performance issues or lack of work, can they still file a claim within 30 days for an injury? We see this happen often when we lay off union workers for lack of work, and then they claim they were injured with no witnesses.
And talk to the insurance company and controvert the claim. Contest it, deny the claim, and let the board, let the judges figure it out, sort out all the information, and make sure you tell your insurance company everything.
Okay. Great. That was the last question from the group. I just wanted to remind everyone, I will have everyone's email address. I'm going to forward out a copy, a PDF version of this presentation as well. We are recording this as well, so we will basically take the content and keep the recording itself and probably post it on our individual association websites, or we can send it out. So do you have any last notes, Mary?
Just make sure you get insurance and pay for it. Don't let it
Okay.
lapse. And if you have any problems or you know somebody else, share our information.
Excellent. Again, thank you from both all of our associations, AGC, Eastern Contractors, and NESCA. I want to thank all of our members for joining us today, and I hope everyone has a great day. Thank you.
Thank you.